Okay. So thank you, Deepan, for sharing the video with us. The Law Union wanted to host this event to highlight the shift that is occurring in citizenship and who's basically allowed to belong and who's not allowed to belong. The Justice for Deepan support group was formed in July 2013 to support Deepan in the quest to have his citizenship restored. So as you just heard from the video and the story itself, Deepan is an Ottawa-born man who the Canadian government is trying to deport to India, a country where he has no family, has never lived as a citizen. And also joining Deepan will be Yavar Hameed. He was called to Ontario Bar in 2001. He's completed his common law degree at the University of Ottawa and a master's in international affairs at Carleton University. Yavar's practice focuses on the protection and advocacy of human rights and civil liberties in a diverse range of legal and areas, including general civil constitutional litigation, administrative law, criminal law, in the context of civil protests and freedom of expression matters, and immigration law. So, thank you.
Thank you for hosting us on the department.
As you guys are aware, my name is Deepan Bolkadi, and I'm just going to give you a little bio of my case from this point on. I got charged for transfer of firearm when I was 19 years old. I went to Ottawa Detention Center. Within a month of being at Ottawa Detention Center, I got an application for a newspaper, went to the hole. From that time, a guard singled me out, contacted CBSA, which is a violation of my privacy rights, and then CBSA said to me that I'm not a Canadian citizen. They considered me a permanent resident at that time. They took away my Canadian passport, took away all my documents, went to admissibility hearing. From that point on, the public safety minister intervened and stopped my admissibility hearing for about 1 year. At that point, I got sentenced to 3 years. I went to Joyceville Institution, and the whole set had recommenced. From that point, in December 2010, I was found inadmissible in Canada, and now I got out in 2013, December 12th of 2012. Got released from federal penitentiary, got arrested, and then went to CBSA. That's not far. Let me rephrase that, sorry. Got arrested at Joyceville Institution, and they transferred me to Toronto West Detention Center. I should have came back to Ottawa, but I went to Toronto West Detention Center. Was held there about 6 months before I got released on bail conditions, for strict conditions, and then from that point on, I resided in my parents' place. Started a campaign in June, trying to fight back the government, and then recently I was in court in November, where I got a lot of my conditions got reduced down to 4 conditions, where now I'm able to work. But in the process, I had to file a mandamus application in federal court. I also had to seek help from the Thomas McClare's office to get my social insurance card. Currently, there is a judicial review for a prop in federal court, as well as a mandamus application, and that's where I'm standing at this point.
So just to follow up on some of the legal points that the Deepan story raises, it's highly troubling that for a person who is a Canadian citizen, he could be put in this position of double indemnity, double punishment, where having served his criminal law sentence, there are added measures. Ones, and Deepan talked about being before the IRB earlier this month, and having conditions imposed upon him. One has to ask the question, when you've completed your sentence under the criminal law, what is this added level, what are these added measures that are being put in place? In any detention review in an immigration context, as in a criminal context, there are 2 questions to be asked. One, whether the individual is a danger, to whether they're a flight risk. Both of these questions were answered affirmatively by the Immigration Division. But again, having from a criminal law standpoint completed the criminal measures, one has to ask, what is the danger? How can there be two sets of danger? One set of danger to the public for people who are, considered to be Canadian citizens, and another for people who are considered to be outside of the purview. I think there's an inherent contradiction there, and there's all sorts of problems we see. We see this, even in terms of the application of the charter to the immigration context, and we know, and as some of you will know, there isn't a clear definitive line to say when basic constitutional protections will kick in, whether it's an administrative process or whether it's a criminal law process. That really what matters is what's at stake to the individual in terms of the effect of removal, etc. So it's a context-specific determination, and we know that at law. But I think what's really troubling fundamentally is that how can there really be these kind of two standards? Now, the second question on flight risk, again, troubling one for someone who is committed to legal processes of challenging, the immigration sanctions against him, has mounted a nationwide campaign that has also had international attention, that Deepan would seek to go underground or not report, were he called to do so by the law. So both of those things, I think, are very troubling, that the Immigration Review Board at the Immigration Division level could find that Deepan should have continuing conditions. This begs the question, the fundamental question, as to whether the Immigration Refugee Protection Act and the IRB, for that matter, should have jurisdiction to deal with Deepan, to control Deepan's movements, and basically to determine that he should be removed from Canada. This is the subject of a constitutional application that we filed in federal court, an unprecedented application to get a determination by the Federal Court of Canada that Deepan is a Canadian citizen. From our perspective, the Canadian government's position has no merit for two basic reasons. One, factually speaking, and we can get into some of that, and what I'm sort of going to be brief in terms of laying out the legal issues, and I want to hear from you guys if you have questions on any of this. But from a factual perspective, the specific provision that the government is relying upon is under the Citizenship Act, a caveat which says that an individual who is born to either diplomatic, people who enjoy diplomatic status, or is part of diplomatic staff at the time of the individual's birth, falls under the authority of the foreign state and not Canada. That's their limited exception, statutory exception under the Citizenship Act. As a matter of fact, Deepan's parents were not working for the Indian High Commission. They were not working for the state of India at the time of his birth. That's just a yes or no question. Were his parents so employed, or were they not? We have adduced clear, unequivocal evidence from Deepan's parents' employer at the time of Deepan's birth that he was working for a Canadian citizen, that in fact his employer, rather his parents' employer, was Canadian. One would think that the matter should simply end there, right? As a matter of fact, either you fit under the Citizenship Act exception or you don't. So factually speaking, the Canadian government's position that Deepan is not a Canadian, I don't think has merit. Beyond that, even if, and I think that what Canada is trying to do is it's trying to look at well, why were Deepan's parents still in Canada at that point in time? Should they not have returned? Is there some sort of way that, by extension, in terms of sort of a constructive way to impose upon them some kind of link to the Indian High Commission, to India, that they can, by proxy, say that Deepan should fall under that rubric? I don't even fully understand how that legal theory would go, but I think it's something of that vein, how the Canadian government intends to justify their position, because we don't even know this clearly. Leave that aside for a moment. The second reason why the Canadian government's position, I would submit, is without merit, is because what Canada has done effectively and still is trying to do is it's trying to remove an individual who de facto and de jure has no state. He has been rendered stateless by the actions of Canada. And as some of you may know, under international law, there's a convention, 1961 Convention on the Reduction of Statelessness. Canada is committed, Canada is a signatory to that convention, and is committed not only to taking measures to guarantee protections for their own individuals in circumstances where one is a Canadian citizen and would otherwise be rendered stateless, but in this kind of a situation, the facts leading up to this this deprivation of citizenship have been caused by Canada. So it's not simply that it just happens ad hoc, that somehow someone's passport has been taken away or lost, or it just so happens that an individual who's undocumented lands in Canada, and in those circumstances, Canada might have some de facto or de jure responsibility for the individual, because you can't place them in the world. Canada is actually actively engaged in having stripped away Deepan's citizenship. In that circumstance, I think it's clear that Canada's international law obligations are to reduce the impact of statelessness, to provide those protections which the International Convention provides for. So in that sense, it's clearly a violation of international law. What we are basing our application in federal court on is that it's a violation of Section 6 of the Charter, dealing with citizenship rights, and sort of the two in tandem. One, that there's not a legal basis for the stripping away of citizenship from Deepan, and the corollary rights that go with citizenship, that basic inherent right that he's enjoyed all his life to either leave Canada, to remain in Canada, or to enter Canada. Those basic rights must continue. So based on all of that, what we're doing simply in our application to the federal court is to say, in these specific circumstances, given that there is no legal basis or legal authority to remove Deepan's citizenship right, that he should simply be declared to be a citizen. That's quite simply what we're putting before the Federal Court of Canada. What's interesting about this, and for those of you who are taking either the immigration course or the advanced immigration course, there are adjudicative processes by which a citizenship may be removed where there have been material misrepresentations, where there's some factual or legal basis for the government to make an argument and to go before the proper citizenship venue to have that right adjudicated. In this case, what is so exceptional is that it's come about simply through a unilateral action of the Canadian government, and not only unilateral. And maybe I'll end my preliminary points and sort of open it up to questions on this front. Not only unilateral on the part of Canada, but Canada has been suppressing information in respect of its communications with India. Now, this is extremely shocking. It's not necessarily determinative of our constitutional application in the federal court, but I think it certainly colors it to the extent that where Canada, and I think Deepan mentioned this, where Canada, in its state-to-state discussions with India, is being told, he is not our national. Deepan is not an Indian national, and they have this information. Clearly, their hearings officers have had it. They've known about it for months, and I would say they may have known about this for years. Despite having this information, they continue to impose conditions, although those conditions have been lessened. They say that Deepan properly falls under the purview of the Immigration and Refugee Protection Act. He's a danger to the public. He's a flight risk. And they don't provide that key information to Deepan from India. This is suppression of information. At the very least, there needs to be full and some kind of frank disclosure as to what the position is of the other state. And I think that even as recently as November 1st in Deepan's Immigration Division hearing regarding a relaxation of his conditions, the Canadian government's position is somewhat nuanced in saying that India is working on it. They're looking at ways in which they can get the travel document. This is sort of hearsay reporting from the hearings officer who is just talking about something she's been told by someone else working in the office of CBSA. Certainly not evidence, nothing that would pass for evidence in a normal court. In an immigration context, we know that the rules of evidence are more relaxed, but it again begs the question of what is actually happening and what has been happening for 3 years between the Indian government and the Canadian government. What my supposition is, and I think it's an educated and founded one, is that Canada, sort of under the motivation of I wouldn't say the principle of double punishment, but motivated by the view that there should be some kind of double punishment against Deepan, is telling India, please remove this person, and it's trying to convince India to take the necessary steps, the necessary measures to accept Deepan as a citizen. Now, we don't have the specific state-to-state communications. We may get this in the course of our federal court application, but it's abominable that there could be these kind of diplomatic interactions between Canada and India, where Canada is exerting some kind of influence to get another state to take, I guess, ownership or jurisdiction over its own national. So it's unprecedented in that respect, and I think it's something I would say is clearly in bad faith, where the Canadian government knows, and we've seen this in a couple of documents where Canada Border Service Agency officials are saying that India does not consider Deepan Budlakati to be a national of their state. So when you have this information coming from India, what more is there left to be explored? Except, again, my supposition that they're continuing to try to exert some influence on India so that India will take control of Deepan. And in the balance, in the meantime, Deepan sort of is situated in this kind of a legal limbo. Maybe I'll just give you like one more brief thing to consider, and then open it up to questions. Do you want to talk about that? Yeah. Oh, okay. Okay, why not?
I just want to point out one other thing as well. Canadian Civil Liberties Association, Saskatchewan, has also filed a United Nations complaint, and based on under international law, like cannot be have no nationality. I just wanted to point that out as well.
Yeah,
Exactly.
that's a good point. That's a good point. So often the United Nations intervention will be the intervention of last redress that's been filed and sort of waiting for a response from the UN. But it dovetails with the application that we've filed in federal court. But the last comment, and I'm interested to hear what you guys think about all of this, is on this broader question of double punishment. Because getting back to some of my preliminary comments is that what is really at stake here? What is at play where there appears to be a different standard for considering risk, for considering danger, and for considering, in a sense, the deservingness of an individual to live and stay within Canada once they've committed a crime because of a constructed identity that they belong somewhere else. Now, we see this at various levels, and just to give you some examples, and you guys might have some thoughts or comments on this, is that I worked on a case a number of years ago regarding a dual Canadian-Sudanese national, Abu Sufyan Abdulrazik, where his situation was kind of the opposite, that he was actually trying to come back to Canada from Sudan. And there's a certain analogy there where he was listed at the time under the United Nations 1267 regime, Resolution 1267 regime, and under sort of the rubric of this, this procedurally unfair association of him to terrorism. Canada didn't want him anymore. They washed their hands of this individual. So it's interesting that even where you have Canadian nationality, there is this constructed identity of someone being lower on either the list of deservingness or the hierarchy of belonging to Canada, where they can be excluded from enjoying their basic rights. So this was quite shocking in the end, and it remains to be seen what Canada will adduce in our federal court application here. But in the case, the federal court application that we launched under Section 6 to repatriate Abu Sufyan Abdulrazik, Canada knew categorically that they were going against both the Charter of Rights and Freedom and international law in terms of the exceptions that they were under the UN 1267 regime. What I suspect is that they know that the same thing is happening in this case, that it's a political motivation based on this idea that somehow, for some Canadians, their relationship to or their right to belong to Canada is subordinate to others, and that can be exercised to keep them out of Canada. In this case, it could be exercised in a way to remove quote-unquote and undesirable people, basically foisting another nationality upon them as a guise to kick people out of the country. And another, yet analogous ground or analogous situation, I would argue, just sort of food for thought, is what we see in the security certificate regime, where and we see this and we deal with this time and again for security certificate detainees, when we argue the question of dangers to the public and the conditions at a detention review. How is it that you can have a man like my client, Mohammed Majoub, who is essentially been in detention or under conditions for 13 years with no criminal charge ever, not even reasonable probable grounds to investigate him under the criminal law, and yet he is considered to be such a threat to Canadian national security that until recently, until this year, January, he had some of the most strenuous conditions of release in Canadian history. It doesn't make sense. But again, it's this notion of the deservingness of that individual to remain in Canada and to enjoy basic protections that we afford within Canadian society. So it's interesting how one may think that for a question of danger to the public, there should be objective criteria. Either you're charged, you deal with it, your sentence is served, and that's it, and that matter is over and done with. But we see this kind of lingering, whether it's a moral basis or some kind of principle by which people in a Deepan situation can be thought to be less connected to Canada. And I'll leave it on this note, and I want to open it up to you guys now. When faced with the federal court application, I think it was the Globe and Mail or the Citizen attempted to get in touch with the Minister of Citizenship and Immigration, and the response that we got from, or rather the media got from the representative of the minister, was that basically if Deepan had wanted to remain in Canada, he should have chosen a different life instead of a career of criminality and the path that he went down. So I would say that kind of rationalization, that kind of rhetorical justification is sort of a case in point for this view that there are those who deserve to be in Canada and there are those who rightly or forget about the law, forget about what the 1961 convention says, forget about what the Charter of Rights and Freedom says. If we can rhetorically say, or if the minister can rhetorically state to the Canadian public that this is someone who's committed a crime, his parents are from India, let's send him back. And I'm astounded to see that there is a lot of chatter within the blogosphere and within cyberspace to say, yeah, maybe he should be sent back, whatever that means. And so I think that it's an interesting dynamic where politically there is, I would say, this racist tendency to want to exclude and to use this kind of moral lever as a measure of double punishment to kick someone like Deepan out of the country. So if you guys have any questions, we'd be happy to address any questions or comments you have.
Yeah, I'd like to address this one to Deepan, and thank you for coming today and talking about your situation. If you're comfortable speaking about them, would you mind expanding a little on the conditions that you've been under since this process began?
Okay. When I was released from Toronto West, I had curfew 9 to 9. My two bondspersons were my parents. They had to abide by the conditions as well. At CBSA asked them for any kind of documents. They were entitled to get the document within 48 hours, or I get breached. QDPs. I was authorized to get a work permit. Sorry. What were the other conditions I had? Essentially, it was a bit, the basis of the worst condition I had was the house arrest, essentially, and not able to work, and having a curfew, and then signing once every 2 weeks was the foundation of my old conditions. That answer that question.
Yeah, and you had to sign in with a probation officer.
I had two places to sign. I had to sign in with parole as well as with immigration.
Okay.
And immigration is only one place, 265 Walkley, 2626 on Walkley. And that doesn't matter where you are in Ottawa, you have to go to that facility. Between 8:30 in the morning to 11 is your time cap. Monday to Friday.
Sorry to interrupt. Just to follow up, how long was it after the disposition of your criminal charges that this process began?
It actually started before criminal charges, before you got convicted.
But after you'd been charged?
The process started in 2010, before I even got charged. Then it stopped, the public safety ministry got involved. And then when I got convicted from my firearms charge, it recommenced.
what exactly happened? Like, I guess I'm still confused about, so there's the criminal charges, but the proceedings started before, and what prompted that, or?
Maybe Deepan can fill in some of the facts, but it's, well, why don't you say the facts and.
Okay. I got the charge, I went to OCDC, Ottawa College Health Center. I got an altercation, went to the hole. An officer came up to see it, said that if I'm a citizen or not. And then I said to him, I am a citizen. So when I got out of the hole, CBSA came to see me. I provided them a document, Canadian passport and birth certificate. And from that point on, it started, they just said, oh, you're not a citizen? I did not see no court or nothing, and then the process started.
So I guess, what happened, and we're trying to kind of piece it together, I guess, what motivated it. But essentially, through the overzealous policing, I guess, of people who maybe don't look like they're Canadian citizens, but while they're in detention, there's an overlap, as some of you may know. Immigration detention is not different from criminal detention. So you're under preventive detention in Ottawa. You go to the OCDC just as if you were convicted of a crime and also sentenced. So it's the same thing, right? So you're in there. So there's kind of an overlapping, I wouldn't say jurisdiction, but ability for Canada Border Services to become involved. And so at some point along the line, and we don't know quite what sparked it, but CBSA said, well, maybe this guy's not a citizen. And so what happened then, just same detention, same individual, they decide to scrutinize him, and they say somewhere along the lines that, well, I think we issued this citizenship by mistake. And by making a unilateral call, a unilateral decision on the part of the public safety minister in conjunction with the citizenship and immigration minister to say that this citizenship was issued by mistake, they then prompted an admissibility hearing. So the thing about in the normal course and admissibility hearing, as you'll know from immigration law, is that it's usually done where you're under the purview of the Immigration and Refugee Protection Act. You are a permanent resident, you are someone who's not a citizen, and CBSA will want to determine that for the purpose of the record within that adjudicative hearing. Are they or are they not a Canadian citizen? And for example, are they inadmissible for criminality or serious criminality? So the first tier of that, or the first question, was already decided a priori. So internally, and we've yet to see the documents that prompted this, they said, well, you know what, this has been done in error, so let's just flip the jurisdiction under the IRPA and convene the admissibility hearing. The premise of our application in federal court is to say, well, you can't do that. You can't just take a citizen and say, well, all of a sudden they're under the rubric of the IRPA. And one of the things, I failed to mention this in our federal court application, I think, is it posted on the website? I'm not sure if it is.
The federal application?
Yeah, no, it isn't. But if those of you are interested, send me an email, we could give you a copy of the notice of application. We're also seeking a declaration that the terms of the IRPA don't apply to Deepan. Because, for one, he's a citizen, and we want all the rights and benefits that inure to that. So it doesn't fully answer your question, because it's unclear to us how that was actually triggered, but it certainly wasn't done in a proper adjudicative way with notice, et cetera. It was just done unilaterally.
That was
Okay. Yeah.
So certainly there are other things going on in Canada that, like as you mentioned, like security certificates with maybe similar motivations behind them. But is this situation, is it unprecedented, or has something like this happened before?
I think it is unprecedented. Where there are, I guess, legitimate bases under the Citizenship Act to, I guess, make a case for someone not being a citizen. I mean, there are procedures and they're like, with respect to a misrepresentation and things where you go before an adjudicator process to vacate or remove citizenship, but that's not what's happened here. So the citizenship, issued in error rationale, I think that's unprecedented.
Right.
And particularly how it intersects with someone who's enjoyed it for all of his life for 2 decades. That is also unprecedented in that context.
It's a little, I guess this is sort of both these questions. So under the Citizenship Act, you can only be stripped of your citizenship for misrep if you were naturalized, not born here, right? So has there ever been a case where a kid has, so say for some reason they could prove that Deepan's parents misrep somehow, like, has there ever been a case where parental misrepresentation has resulted in children losing their citizenship? Or is this totally just out of
I don't know.
nowhere?
I don't know of such a case.
I don't either, but.
Yeah.
All right.
Yeah. Other questions? Just yeah.
So you talked about how the government of Canada suppressed information. Could you talk more about that? And are you going to argue using that in terms of like procedural fairness? Because he has to be given all of the evidence, right? Like he has a right to hear, like examine all of the evidence that's against him. So yeah.
That's a good argument, and we've. I should have brought a copy of our notice of application. That's part.
It might be on the,
Yeah.
it might be on the site.
Yeah, that's part of the argument. It's not really the thrust of what we're arguing before the federal court, in the sense that either he is a citizen or not. One of the ways that I think it's relevant insofar as we're arguing a violation of his basic constitutional rights. The federal court is weird, and charter litigation is weird as well. Recently, in a security certificate case that just came down in Mohamed Majoub, the federal court ordered that Mr. Majoub's fair trial right was violated, but the certificate was upheld. It's kind of a weird way in which to deal with a charter remedy. So the way in which, sort of by analogy in Deepan's case, one can use I would say this background of bad faith is to say, in these circumstances, at the very least, given what the government of Canada has done actively to suppress information, that is a reason for which a declaration and the rights that we're seeking, the declarative and other rights for Deepan should be given as a remedy. So I think it's something that might buttress our remedy under Section 24(1) of the Charter. Procedurally speaking, I'm not sure we necessarily want to go down that road of actually needing to adjudicate something, because we don't think that needs to be adjudicated. The facts are basically what they are. It's up to the Canadian government to come up with something today that says something different, that he's categorically not Canadian. But just in terms of the actual facts, what we learned is in April of this year, the hearings officers had clear information from India that Deepan's not an Indian national. So that information should have been provided to Deepan, and I don't see how it was suppressed.
So,
John?
sorry,
Oh, sorry.
how did you find out then that it was suppressed?
Through Deepan has made a number of Privacy Act applications.
Okay.
So where that's something that continues to be unraveled in terms of how he got into the situation, and just knowing what I know about some of these very contentious cases, like we're only at the tip of the iceberg.
Mm-hmm.
There is likely reams and reams and thousands of pages of information, and what I would suspect, and I don't for those of you who are interested in working for Department of Justice one day or whatever, there are people out there who are probably DOJ lawyers, or probably in-house counsel for whatever, saying, and I'm sure of it, saying, this is wrong, you can't do this, you can't strip away citizenship. I mean, we've seen this kind of thing in Abdul Razak's case, and someone, one of the political higher-ups is going to say, well, you know what, it's just the way we're going to do it. And I haven't seen that yet, but I suspect that that's the case. John?
Yeah, I guess I was
gonna ask kind of a related question. Correct me if I'm wrong, but is there a section under the Privacy Act, like sort of an exception for information provided from other states? Okay, and is there a possibility that they will apply that exception to sort of deny the rights to know the case, Deepan's right to know the case against him, and you'll end up in sort of a national security kind of context where there's information but they can't tell you what it is? Is that a possibility?
Kind of. That's a good question. I mean, it's one of the things that we are running up against. I mean, how many Privacy Act applications have you done today?
Close to 54.
54.
Close to 54.
He's done 54 applications, so he's on top of it, and he's processing. There's many that are requesting extensions, delays, partial information disclosed, and we've only really, as I say, we've hit the tip of the iceberg in terms of some of these, and Deepan, is assiduously going through all of these and trying to piece out some of the stuff that is helpful to the case, but there's not a lot that's coming through. The state-to-state exemption from disclosure is a huge obstacle. I mean, if India would come forward, and it doesn't have to, right? We have overtures being made directly to India to, talk to them and get that information directly from them, and we hope that they'll come through on it. But it's embarrassing. It's very embarrassing for Canada. It would become an international relations issue if India came forward and said, you know what, you're right. He's not an Indian national. You're right all along, and Canada is going to have egg all over its face. So, we suspect that that's there. It may come about, but in answer to your question, that exemption under the Privacy Act is an absolute exemption, pretty much. You can try to pare it back to some extent, to the extent that it's being over broadly masked, like what Deepan has seen, and the disclosure that we got on the issue of what the hearings officer had was internal emails shared within the Canada Border Service Agency, which said that the Indian government is not issuing travel documents because they take the position that Deepan is not a national. So that document, maybe it was an error, maybe they should have redacted it, right? But I would argue is that where it's an internal document, it's not necessarily state-to-state communication. We're entitled to see that. So there's kind of like a gray area where you can sort of indirectly access that information, but it's tough because if we simply had access to those state-to-state communications, it would be even more embarrassing for Canada, the situation.
I want to point on to that as well. One direct ATIP I requested for communication between CBSA and the High Commission completely got blacked out. But then I got a document from the High Commission saying that please contact CBSA Realty to furnish their decision. So from that point on, there's an appeal process going to get information because the High Commission has already stated that they would give the information to CBSA and contact CBSA if you want information. So that's one way that trying to go around for that specific ATIP, where that rule has applied.
So just follow-up question.
Sure. And I guess, is there any process in India to try to get that information?
Good question. We're exploring those avenues. Okay. We'll keep you posted. Good question?
Yeah, moving a bit away from the procedural stuff, which is very interesting. I'm interested in the connections to the broader context of like the growing government hostility to certain racialized immigrant communities that we see in like the security certificates in here, and generally under the guise of whatever national security policies. But I see that the way the government's treating you, Deepan, there are clear implications for the sort of very established immigrant and diasporic communities that the way the government is treating you. And I'm wondering what sort of strategic connections you've made to those communities, particularly as the Conservative government is trying to leverage those communities in their sort of ethnic vote drives. So like what sort of connections have been made, or what strategies have you considered, or would you consider in working directly with South Asian communities in particular around the implications for this, for them more broadly? So, because you can see if the government's doing it here, they could easily do it again, and those communities are you know, they're very established and they're growing. And some of them are very desirable immigrants, so to speak, and their children are citizens. Like, I'm a citizen because my dad immigrated here from India. Like, I could be caught in the same thing by the government's rationale. So I'm interested in sort of, outside of the law, what sort of strategies around leveraging that have been happening.
I kind of have an answer to that, and I think that, I don't know what you've seen, but it's weird, eh? With the way in which immigrant communities, new communities, naturalized communities respond to cases, contentious cases, where there is an element of criminality in the background, is different from just a frontal attack and an undisguised attack against communities. And so it's tough. Like, I would say in the security certificate context as well, and we've seen this on with respect to many of the cases, that the Muslim communities, the Arab communities, and those ethnic communities from where the concerned person comes from originally, they tend to back away. It's tough because I would say, for the most part, those people who are directly caught in the crosshairs, who see themselves in a similar position, would tend to come forward, except those people are the most marginalized to begin with. So I hear what you're saying, that there is maybe, in a sense, a natural strategic alliance that can be made. And I think that in terms of some of the more activist communities and organizations, like the support committee for Deepan is forging those links, and Eloy is here, and we can speak to that as well. Like the different organizations, No One Is Illegal, and other coalitions of organizations that we're seeking to make links with, and I think that's important. But it's not necessarily the broader community that would step up. One of the thoughts that comes to mind as well, for those of you in your immigration course who have studied this, at the turn of the century, you probably read about the continuous journey requirement, where Canada created this rule where you couldn't, even where you were under the umbrella of British rule, you couldn't come to Canada unless it was a continuous passage. So it wasn't a way, and this was particularly and pointedly done so Indians couldn't come all the way from India to make it to Canada, because they're under the British Raj, the British Crown. They should have a right to come here. So through an indirect way, Canada devised this skillful measure to say, through a neutral rule, that, well, you can't make it by a direct passage. You're not really, you're not allowed to. Sorry, we can't do anything about it. So I find it kind of interesting. In Deepan's case, it's sort of like, well, it's not racism. We're not saying that Indians don't belong or can't be naturalized, etc. But he did choose a path of criminality. So if he wanted to stay, there's other things he could have done. But this isn't racism. It's not that at all. It's a clever way in which to say that there's some people who just don't really belong, and they need to be sent back. Forget about that. It's not his country of nationality. It's a rationale, a political rationale to leverage that exclusion.
I'm actually going to ask a question,
Sure.
just following up to what Maya just said. On a larger scale, I know Kenny last year was going on, he's the former Citizenship of Immigration in Canada, and he was in the process of stripping a lot of migrants' citizenship status, right, for either for criminality reasons or saying they don't live here long enough, or etc., right? And I guess well, my question is, do you feel that they're trying to set a precedent by allowing the stripping of citizenship? And if so, how can we resist that, and how can we support Deepan in this process? And what role do you see law students or even the broader community playing?
Sure. So what? So in terms of the political move to set a precedent, I don't know. I don't know necessarily whether it's a calculated move to set a precedent of certain kinds of cases. I know that it's something where the hardline law and order government of the day sees that there is a constituency, the very broad constituency, that wants people either to, one, pay for their crimes, and also to basically go, quote unquote, go back where they come from. So there is that very sort of racist constituency which exists, and from which you can get political votes or political support. Beyond that, whether the government's trying to set a precedent, I'm not sure necessarily that's the motivation, but it's certainly a very dangerous effect of a case like this. And Deepan could talk about how we can resist.
Okay. Support-wise, I have an action coming up on Wednesday. It's a phone and fax jam. It's posted on the site as well. It's just basically jamming up the lines and fax for the immigration minister and the MP, just basically showing that they're supporting the community nationwide. I have an online petition on my website. I'm looking for people to sign my online petition, as well as a side campaign with the postcards, asking people to sign the postcards. I have an Indiegogo site, Public Defense Fund, as well as you get different types of perks. I have a Facebook page and a Twitter. I'm looking to get more people on those two social media aspects to be aware. And I am doing a speaking tour in January, and I'm always looking for more connections further out in different cities around Canada where I can speak as well. So these are the types of things that I'm doing as well as looking for support.
You kind of talked about this already, but you talked about kind of the rhetoric at play in the public, and you've also talked about the legal strategy. And I'm wondering how much those are coming together, or if they're just two separate things. Like in terms of like, if he wanted to be a Canadian citizen, he should never have broken the law kind of thing, versus like what they're actually saying in court. I'm wondering how much those work together, if they're kind of parallel lines, or...
I don't know that they're, in a case like this, I don't think, well, it remains to be seen because we haven't got a substantive response yet on the federal court application. We actually don't know how they're going to rationalize this. I suspect that kind of rhetoric is just pandering to communities. It's not going to wash with respect to the very specific factual and legal questions that would be before the court. Implicitly, I think it's a kind of thing maybe that counsel would make in argument to just add a sort of a rhetorical flourish to their argument, but it can't be a central theme of how they rationalize it in court.
So then in terms of that, sorry, just a quick follow-up, like which do you think is their most, is it all going to come down to the court decision then? Or like do you think there's, how important is this beyond, in terms of the rhetoric to the ultimate, whatever ultimately happens to Deepan, which one is the more important struggle for them, or are they kind of, I don't know if I'm being clear.
I think I understand your question. The rhetoric is one thing, and I think that, it's part of the political agenda, right? The interesting thing about the legal case is I think it kind of, it extracts itself from that rhetorical context and just, it cuts straight to the legal question. So in a sense, if we can, get a positive decision that focuses on the real live legal question before the court, it will be a real embarrassment to Canada because they're trying to add all this, window dressing and obfuscation of the issues out there. So I think that remains where they're at politically. The sort of the constitutional answer to it is something I think which is really the nub of the question, and that's where the ultimate determination should be made. And sometimes it's so obvious, that we see this as an answer, and I think maybe many of us in this room could agree that it makes sense. Like, this is a declaration that the federal court of Canada should grant. But getting that is another question, because it would take courage for a judge to do that, and there's some judges who are maybe more courageous than others. You'd be setting new law and taking a firm stance on a human rights issue. But I would say that in many senses, that's, if we can just answer that, which is the nub of the issue, all the rest of this evaporates.
To return to what you started talking about today, I'm curious, because maybe I got confused in the narrative, but to what extent is the factual question about the nature of Deepan's parents' employment, the circumstances of their employment, dispositive of the whole case?
I think that it is it's a central issue, because if they were employed as diplomatic staff or the adjuncts to that staff, they fall within the exceptions under the Citizenship Act, and that's appropriate. That is a defense. That's a basis to say, leave aside what might still be the case, which is like even if they can fit within that exception, if India takes the position today, which we've seen, that he's not a national, the effects under Section 6 and the Treaty on the Reduction of Statelessness, those still kick in, because India's de facto position still holds, because Canada just can't relinquish that citizenship having given it if the corollary is to create statelessness. So I think that it's probably the best thing that they could hang their hat on as an argument. But I think the strategy, and again, this is speculative on my part, is one, they're trying to enter this gray zone of saying, well, constructively somehow make the argument about a link from Deepan through his parents to India. That's one part of their argument. But in the background, they're trying to cajole India to actually, renege or change their mind as to his view or their view as to Deepan's citizenship status. And I think it's a very significant question, because looking into the process of getting citizenship from India, it's a very involved thing. Like, you can't, for example, you can't have dual citizenship with India. It's a very involved process. You'd think, like a country with, 1 billion people, maybe it shouldn't be so hard to, add one more citizen. It is. It's hard to become a citizen of that country.
Not that I think like it should get to this point, and I agree that really the IRPA shouldn't apply to him. But if it came to it, like, is there some sort of humanitarian, compassionate argument that could be made in this case, in terms of the fact that he was born here and has spent his entire life here? You spent your whole life here and have no connection to India whatsoever. Like, it would be so disruptive to your life. Like, is there anything there?
There's a humanitarian compassion grant application. By me filing it, it's basically saying that I'm not a citizen.
Yeah, I know.
So
Yeah.
there's no point in me filing whatsoever and then that's where the United Nations complaint has gone in, and
Right.
application gone in to correspond with humanitarian compassion aspect.
Right. So that would be the, because I mean, I know there's like an agency in IRPA, but like so the UN is the sort of outside of that? Like, there's nothing else in Canadian law or?
There is a citizenship agency too, which is kind of a fallback position, but I would say the more direct pathway, and we could use that sort of if all else fails, but there's the court application is, I mean, it's, for those of you who have looked at essentially mandamus applications where a court is forcing a minister to do something, it's very highly protected grounds. I mean, the court doesn't want to go there. And in a sense, it's not the ideal situation to be in, but as a backup, to basically ask the minister, exercise your discretion to make Deepan a citizenship or declare that. That's always there in the background.
Right.
As a fallback.
I think your application might be online, because I think that's why
No.
Okay.
Yeah, it's all good.
So my question, because I think you said you were making a charter argument based on Section 6. is that right?
Yeah.
Was there any other basis that you investigated, I guess, or is there anything else included in the application, or? I'm just curious why maybe you didn't look at section 15.